Look at whether the sentence promotes respect for the law. And equal protection, equal justice under the law is how we promote respect for our citizens. It's the cornerstone of our entire justice system, or at least it's supposed to be. And so the argument I would make is to say, when you perpetuate a racist statute, you are in effect promoting disrespect for the law.
Over 1 million Americans face sentencing every year, and it will be the most important day of their lives. But we don't fully understand the system, how broken it is, and what we can do to make it better. I'm Doug Passon. I'm a 25-year criminal defense lawyer and a sentencing expert. My goal is to bring more awareness, more fairness, and more humanity to the sentencing process. So, are you ready? Then let's get set for sentencing.
Hey everybody, it's Doug Passon coming to you from Studio 3553 in Scottsdale, Arizona. Today, we are going to be talking about racism. More specifically, the racist origins of what is, at least in my practice here in Arizona, a border state, one of the most frequently invoked federal criminal statutes that we have. It's called Section 1326, and it's otherwise known as the illegal reentry statute. This is a statute where someone's prosecuted who doesn't have documentation to be in this country, and they've been deported or removed, and they come back without permission. And what people don't understand, because we talk a lot about how nobody's enforcing the borders and open borders and everything else, that these cases are prosecuted in massive numbers, and the sentences can be terribly severe. So I am so excited because helping us get set for sentencing today is an extraordinary attorney and also a friend of mine. Her name is Kara Hartzler. Hi, Kara. How are you?
I'm great. So excited to be here.
I'm so excited to have you here, too. So I first met Kara when she was working at the Florence Immigrant and Refugee Rights Project here in Florence, Arizona. It's an amazing nonprofit that helps people with all sorts of issues. And by the way, I would encourage you to go check them out too. Kara's not there anymore, but I'm still plugging that organization, and so is she, because it's amazing and they're still going strong. They're stronger than ever, doing powerful work, and that's www.firp.org. Check it out, but I digress. So Kara left there and she went to the federal defender, which is my old stomping grounds, not here in Arizona, but so she became a federal defender. She's been there over 10 years, and she has been involved in some really, really amazing, powerful litigation that we're going to talk about today, attacking this immigration statute as being racist in origin and therefore unconstitutional. Here's something else I love about Kara. She is a natural born storyteller. She actually, in a prior life, she got her MFA in playwriting, Master Fine Arts. So she's a playwright, and she's written plays that have been produced here in the States and in Mexico. So, she's a legal powerhouse, but as you know, because I've been saying it over and over and over again on this podcast, all that legal stuff must be packaged into a powerful story. That's where the real victories happen, and she knows that better than anyone. So welcome, Kara. I want to dig in because I just want you to tell me the story of this statute that you have been involved in litigating for quite a while now, right? A couple years?
Yes,
yeah.
Couple years.
All right. Tell me about that. And by the way, Kara has a PowerPoint, and it's a really pretty one. She knows she's not just a storyteller, she's a visual storyteller. So she's got some awesome slides that kind of bring to life what she's about to tell us. So if you're listening to the podcast on the audio version, you may want to pop over to YouTube and watch the video version, or not. It's really kind of cool what she's up to. So take it away.
All right. It is so great to be here. And I'm really always excited to talk about the history of this horrific law, which sounds strange, but the more information that we get out there about it, the more people can really understand its scope and why it's so problematic.
Yes. Oh, and by the way, I mean, this is set for set. Sorry to interrupt, but just so people, stick around because we're going to make this very relevant to sentencing. This isn't just about the statute, but what we can do about it and how we can make use of it at sentencing. Sorry, go ahead.
All right. So I started working in immigration in 1994, right after I just got out of undergraduate, and I went down to the border. I was living near Brownsville, Texas, and I was working with a lot of asylum seekers. And since then, as Doug talked about, I worked in Arizona. I'm now actually in San Diego, California, so I've sort of moved west. So I've worked in some capacity on and off in immigration for about 30, almost 30 years now. So I thought that I was a person who knew a lot about immigration. And then up until a couple of years ago, I realized that there was this whole area of history behind our immigration laws that I knew nothing about. And that people like Doug and others in the federal system who have been representing people charged with this crime of illegal entry and illegal reentry didn't know anything about. So, just to give a little background on how I kind of came to find out about this, I think we all kind of remember in 2018, there was the child separation policy, where essentially families who were coming to the border, the southwest border, would cross, and then the parents would be separated from their children. Their children would be sent one place, and the parents would be basically sent another place for prosecution with no system or plan or even intention in place of ever having those parents and children reunite. So I work on the border. We suddenly had this huge influx of cases as part of this zero tolerance policy that were being foisted on us. And we had just desperate parents, people who were so traumatized, who you could barely even talk to about their criminal case because they were so out of their minds with grief that they couldn't even focus on that. So my office started putting together some systemic challenges to this zero tolerance and Operation Streamline. And as part of those challenges, as we were sort of looking through them and realizing what was happening on the border, this article came out in the Washington Post. And it was all about how this law that was the heart of this child separation policy that was going on, how it came to be in the 1920s. And myself and pretty much every lawyer in my office, many of whom had been doing these cases for decades, had no idea about this history and how this law was passed and the origins behind it. So a lot of this came to light because of the work of a historian at UCLA called Dr. Kelly Lytle Hernandez. And she talked about this history, and we decided to put this into as sort of part of our systemic challenge as a way to push back against all of this zero tolerance policy. So we reached out to Kelly Lytle Hernandez and we got her to be involved and write declarations and be part of this history and this legal challenge that we were doing. So this is a little bit of an explanation of what this history is. And the more I got into researching this history, the more just utterly shocked and horrified I was. So I want to just give a little bit of a taste of this history. I won't do my full presentation, but I'll give a little bit of background on this law so that people can understand kind of where we're coming from on it. So in the 1920s, there was this huge movement over eugenics. And the idea of eugenics is, well, we should try and build a better human biologically. And it was actually a movement that was really done by a lot of liberals, frankly, in some of the elite institutions on the East Coast. And the motive, presumably, was to try to say, okay, well, we're going to wipe out things like disease and certain genetic tendencies that bring sadness. And, so there was this purported desire to make people healthier and happier. But inevitably, as always happens, we decide who is healthier and happier by reference to who is in power and who is white. So, frankly, eugenics got very, very mixed up in this whole idea of, well, who is the healthiest, most superior human? And so we started seeing books like The Passing of the Great Race, where there's all of these theories about how people in the northernmost areas of Europe, in Scandinavia and in some of those areas in Germany, they present the most ideal human. And then as you keep going further south in Europe, then you get the less desirable humans. So by the time you get down to, for instance, Southern and Eastern Europe, you have what are known as the undesirables. And not coincidentally, right around this time in the early 1900s, there was a large influx of immigrants from Southern and Eastern Europe to the United States. And they were known as undesirable immigrants. I'm showing a couple cartoons from this era that talk about, this flood of undesirables. One of the really common ideas during this time is that immigrants from these slums of Europe, so to speak, were often known as rat men. They were, infesting the United States and bringing disease and all these horrible, undesirable traits to the United States. And so around this time, in what was also known as the tribal 20s, when the KKK arose and when there was a lot of desire to keep people out of the United States and limit immigration, these people from Southern and Eastern Europe were considered sort of the top priority, that the government wanted to try to, lock down immigration to keep people from these areas out of the US. So there starts to be this movement to do something called the National Origins Act in Congress, aka the Johnson-Reed Act. And the idea behind this is that there would be really, really tight quotas that would go back to the numbers that would only have let people in from Northern Europe and the areas that were considered more desirable. So this kind of movement is gaining a lot of momentum in Congress. It's pressing forward, and suddenly it hits this wall of resistance. And the wall of resistance comes largely from agribusinesses in the Southwest. There are a lot of large ranchers who need workers to come in and basically harvest all of their crops. And most of these people are coming from Mexico and Latin America. And so they don't want any sort of quota on people from that part of the world. That's where they get the money. That's where they are, that's what's making them rich. So they are very dead set against this idea that there should be these quotas put on everyone from every country. So as a result, there is an exception in this 1924 Act that restricts the quotas to parts of the world that are not in the Western Hemisphere. In other words, there's no quotas for people coming from the Western Hemisphere. So that passes. Then, as a result, all of these people in Congress who still are driven by this really anti-immigrant fervor are not satisfied. And they say, we want to figure out a way to restrict immigration from Mexico. We severely restricted immigration from Southern and Eastern Europe, and now our goal is to try to keep people from south of the border out. But how do we get around this resistance from all the large ranchers who need workers to harvest their crops? So there are 5 people who really become extremely important in this movement to restrict immigration. And I'll just briefly introduce them. One, for instance, is Representative John Box from Texas, who would travel around and do radio shows. And he talked about, in very explicit, horrific terms, about how there are people called Mexican peons. And the Mexican peon is a combination of the Spanish peasant from the Mediterranean, indigenous people who didn't fight to extinction, combined with Negro slave blood. And if we let people like the Mexican peon come in, it's going to degrade our racial stock through mongrelization. Mongrelization was a big term at this time, this idea of racial, crossbreeding, that we can't let that happen because we will dilute the superiority of the white race. And so they were very open about saying the purpose of our immigration laws is to prevent this type of quote unquote mongrelization.
Wow.
So,
It's shades. I mean, you're talking about the 20s, right?
mhm,
I mean, and then you go into the 30s. Those are things you would hear coming out of Nazi Germany 10 years after that. That's like giving me shivers down my spine. And of course, we're hearing shades of it, echoes of it today as well.
of
But
course.
yeah, wow.
Interesting. You should
Okay.
bring up Nazi Germany. We'll get to that in just a second. So another person was Albert Johnson. He was actually a leading eugenicist in the United States. He was the chair of the Immigration Committee. He talked all about the biological aspects of immigration. Another person, which is who relates to Nazi Germany, is a guy named Harry Laughlin. Harry Laughlin was actually a retained eugenicist. Amazingly, the House of Representatives for about 10 years had their own eugenicist who would come in and do all these presentations during congressional hearings. And there's this one infamous hearing where he came in and talked all about the necessity of having immigration be a matter of blood and biology. And he talked about how, a prize breeder of thoroughbred horses would never, recruit for his stud farm someone of a lesser value. And most disturbingly, he kind of talks about deportation as the final selection. Obviously, a chilling forebearer of the final solution during Nazi Germany.
Hmm.
And in fact, Dr. Harry Laughlin was the author of the model sterilization laws that Nazi Germany then adopted several years later. And he received a prize from the Third Reich in 1936 because they essentially credited him with a lot of their theories that then they implemented during the Holocaust. So
Wow.
it's
That's
terrifying.
wild. Because I mean, in my whatever studies I've come across, I've heard how the Nazis took a page out of our book with the way that we treated our American Indian population. And I've heard that they took a page out of our book the way we did segregation and racial discrimination. But this is the first time I've heard that we are the progenitors of eugenics, essentially. Wow, yeah, that's a
We gave the
bomb.
Nazis the blueprint for sterilization and using genetic theories of genetic superiority to shape the content of the population.
Sounds like a whole lot of critical race theory you're dropping on us, Kara.
Well,
I don't want Marjorie Taylor Greene to be listening to this because she's probably Googling how can I hire a house eugenicist right now. Like, let's not give them any ideas.
uh,
All right, sorry.
let's
I'm
hope
not
we're
man, I'm
past
not
that.
trying to make light of this. It's just
Yeah,
sometimes in our business it gets so dark you have to
exactly.
lighten the mood a little bit. But okay, keep going. Sorry.
That's
Go
okay.
off on
So
these tangents. It's a little ADD.
this is really really heavy and horrific stuff, but I think it's incredibly important to talk about because for how many years this was not known at all.
Yeah. And
So
especially because honestly, it is, the biggest rap on CRT in general is whatever, that's the past. And I say, you're not living in the past. The past is living in us. And so what all we're doing is leading up to how this is systemically implements racism that we still deal with every single fucking day in the United States federal court. So this isn't history. This is now. And I just need my people who are tuning in to understand that's what this is. This is now. Sorry.
yeah,
Another digression. I'll stop
that's all right.
interrupting you.
That's all right. So another person who was really instrumental in this was the Secretary of Labor, James Davis. At the time, there was no separate committee for immigration or no separate department for immigration. So it all fell in the Secretary of or in the Department of Labor. He was actually also a eugenicist who really coined this theory of rat men coming to the United States. And then the final person who was a huge part of this, the creation of these laws, was Senator Coleman Blease from South Carolina, who was essentially a suspected member of the KKK. He was just never met a racist cause he didn't like. And he supported anti-miscegenation laws. He supported lynching. He read a poem on the floor of Congress called "No N-Words in the White House." If you name it, he probably did it. So we've got all of these very powerful people who are trying to push forward some sort of immigration law to keep people from Mexico out of the US. But they keep running into resistance from large businesses who need the agricultural labor. So suddenly, Coleman Blease and James Davis hit on this idea. And the idea is, okay, what if we don't create an immigration law that keeps people from getting visas or keeps people from coming legally to the United States? What if we instead pass a law that allows people to come here, but then once the harvest is over and there's no need for the agricultural businesses to use their labor for a while, then we can actually sweep them up, charge them with the crime, and then deport them. In other words, this works really well for the large businesses because they get their labor, and sometimes people might be charged with a crime and even deported before they even have to pay them their wages. So suddenly all the agribusinesses are happy, and it just allows the people who are trying to push from a eugenics point of view, the expulsion of people from Mexico from the United States, it allows them to still further that goal while the businesses are benefiting from the labor. So as soon as this idea gets proposed, it flies through Congress, literally in a matter of a couple of weeks. It's known as the Undesirable Aliens Act of 1929. And it creates pretty much word for word the same law that we have now in the form of 1325 and 1326. There have been some minor changes here and there, but for the most part, it's the exact same law. So fast forward about 40 years, and suddenly all of these laws that were passed during the 1920s that were passed on the basis of eugenics and race, they're all repealed in this 1965 Hartzler Immigration Act. They take away the quotas, they take away all the racially motivated immigration restrictions, except they don't do anything to illegal entry and reentry laws. Those are some of the only laws that are kept on the books from that era. So keep fast forwarding, and we get to 2018. At this point, when we're in the child separation phase, the zero tolerance phase, immigration offenses have become 70% of our federal criminal docket. They are twice as much as all other federal crimes combined. That includes drugs, fraud, child porn, wiretapping, terrorism. We think so much of federal criminal law is about, really, really serious crimes, like the worst of the worst crimes. But for at least the past several decades, immigration has been one of, if not the most prosecuted crime in the United States. And all of these immigration prosecutions stem back from these eugenics-based laws that were done to try to keep people from Mexico out of the United States.
And by the way, these prosecutions have been equally doled out by no matter what the administration is. And in fact, I think they even went up under during President Obama's term. So the whole narrative that Democrats are soft on immigration is another myth. that
Absolutely.
people need to understand. And just to give a little context for what this looks like, because you're you're a border state down in San Diego, right? I mean, a border city essentially, and
Mhm.
I'm a border state in Arizona, and I labored in the salt mines of the federal system, as do you now. And what you see is just an endless chain. I mean, if you think about the 70% figure, and you're going to get here, I'm sure, but immigration ostensibly should apply to any person. Canada, a white person, Norwegians. We didn't see a lot of Swedes on the chain facing arrest. What's the percentage of Hispanic or Mexican, South American, Hispanic population that bears the brunt of this statute? What's the percentage?
I mean, it varies anywhere between 95% and 99%.
Yeah. Almost every single person that's
Almost
ever
every
going to be charged
right.
is
And what's
is is
interesting is
Hispanic.
that now we know from statistics that most of the undocumented population that's now coming to the United States is not coming because they're crossing the southwest border. They're coming because they're overstaying a visa. But we never made overstaying a visa a crime.
Hmm.
So all of the people, if it's were just a matter of going after people who are undocumented, you would think that Congress would have made that a crime. But Congress only made it a crime to essentially cross the United States border unlawfully.
And I just do want to give a little bit more of a picture for people of what this means with the 70%. What it means is they have so many of these cases, and our system's not built to process those kinds of cases in a way that results in a just result. So what they have to do is shuffle them through the system as fast as possible. So they have this thing called the fast track program, or what do they call it, rocket docket, or what's that word down there, the streamline, Operation Streamline, which is code for we're going to fuck you and fast, and we're going to get you through this system where you have virtually no opportunity to challenge any aspect of the case. So as you can see, we get to swear on this podcast. But so what happens is the punishments can be very severe. They'll offer a plea agreement that's going to be much better and give you very little option. And then you're pleading guilty quickly, and you're getting sentenced quickly. And then you're doing time, and then you're getting deported back to Mexico. But it's an assembly line justice system, and it feels very hopeless a lot of the time. Your litigation gave some hope. So,
Yeah.
yeah. Okay.
So let's go ahead then and move to the litigation. So
Yeah.
I'm we're starting to research all of this right around the time that COVID is hitting. And so COVID hits, we all start working from home, and we're thinking, okay, we know we've got all this horrible, horrific history. How do we turn this into a legal argument? And so myself and some of the other people in my office start, researching, and we look through and we say, okay, seems like an equal protection argument, but what kind of equal protection argument? There are three ways that you can usually bring an equal protection argument. One of them is because a law maybe discriminates on its face in the words of the statute itself. Another way is because the law itself may not discriminate, but it's applied in a very racially discriminatory way. So, for instance, more people who are of a certain skin color are prosecuted for having firearms or that sort of thing. You can develop a lot of that with statistics. And then the third way that you can do an equal protection challenge is, has Congress or a legislature enacted a facially neutral law with a purpose or a desire to discriminate against a certain group of people? And that seemed like the exact match for what we had here. We had a Congress who was obsessed with eugenics and who was trying to pass a law that didn't specifically say we want to keep out Mexicans, but in every way, shape, or form, that was its purpose. That's what it was designed to do. So we decided, let's bring a challenge under this. And the framework for that is something that is set out in Arlington Heights, the Supreme Court decision from 1977. And the premise of Arlington Heights is that a law violates equal protection if it's created with a discriminatory purpose. And the way you show that discriminatory purpose is you have this non-exhaustive list of things you can show. Does it bear more heavily on one race? What's the background? What's the sequence of events? Does it depart from the way you would normally do cases or come to certain conclusions? You can point to the legislative history. You can point to its impact. And so all you have to show is that discriminatory intent was a motivating factor. You don't have to prove right at the outset that it was the only reason for passing a law, just that it was one of the reasons. So we decided to write this motion talking all about the history of 1325 and 1326. The first thing we did is we got a declaration from Kelly Lytle Hernandez talking about the history behind this law. And then we went through in our motion to dismiss and told the story that I just told you all about the resistance of agribusinesses and the push by these 5 people to try to get some sort of law through and how it got passed. And then once we prove that at least one motivating factor was this desire to discriminate, the burden shifts to the government to show that this law would have passed without the discriminatory purpose. So we start putting on evidentiary hearings. We start asking to present expert witnesses, and we call historians. I put in a shit ton of congressional records with all of the quotes that I read to you earlier. And we just want these judges to hear our story, to listen to how this law got passed and how incredibly clear the record is that the point behind 1325 and 1326 originally was to keep people from Mexico and Central America and Latin America out of the United States.
Okay.
So we start filing these in our district. We send this motion out to anyone who wants it. Other people start filing it, other federal defenders, other federal CJA panel members, other criminal defense attorneys. They start filing it in all these cases. And, our judges in our district weren't necessarily giving us evidentiary hearings. They didn't think that they didn't agree with the argument, and so they wouldn't let our experts come in. But judges in some of the other districts start holding evidentiary hearings, and they started having day-long evidentiary hearings where people would come in and testify and talk all about the history of the law. And then about, I would say maybe a year or two after we started filing these, we got the most amazing decision where Chief Judge Miranda Dew in the District of Nevada granted this motion to dismiss in one of the cases. She said she agreed that it was based on this unconstitutional discriminatory purpose, that the government hadn't met its burden to show that the law would have passed without this, without this intent. And so she dismissed the person's case and said the law was unconstitutional.
That went off like a bomb. We don't win those kind of big motions. So that news spread like wildfire. And hats off my friend Lauren Gorman, who is a federal defender in the District of Nevada. I think she was the point person on that litigation. So
Lauren Gorman absolutely
did so cool.
An amazing job on that case. She just nailed it and got the most amazing results. I'll be honest, I didn't necessarily think we were ever going to win it, but that's not the point. The point was that we needed to be talking about this. We needed to be asking why such a huge amount of the resources in our federal criminal system are going to prosecute and incarcerate people who are essentially committing glorified trespassing, and why we're spending all this money to do that. So I wasn't doing it because we were going to win, but it was really great when we did win.
Well,
Um,
and that's a great takeaway. I like to make this practical, and I think there are a lot of takeaways we'll talk about, but that's a good one that sometimes we file a motion, even if we don't think we have a shot in hell of winning, as long as it's not frivolous. We're not allowed to file frivolous motions, but sometimes you shake the trees and see what falls out. You know,
exactly.
it also just a light went off because when I first started in the federal system, you know, Arizona, it has a lot of Indian reservations. So the big bulk of our cases, besides immigration, were crimes from the Indian reservation based on the Major Crimes Act. And I did a deep dive into the history of the Major Crimes Act. And I don't know if it's as compelling of a case as the immigration stuff, but there's definitely racist intent behind that. The whole story of how and I won't go into it now here, but that's probably a good podcast I'm going to do. But we litigated that, and there's a bad case law in the Ninth Circuit. But I'm just wondering, now that you guys have had some degree of success in this, maybe it's time to revisit that too. But here's the real sort of interesting part that people don't necessarily understand the jurisdictional issues. But just because Lauren Gorman kicked ass in the District of Nevada doesn't mean that the statute falls. It falls maybe in the District of Nevada in that one district, perhaps or not. You tell me. But what's the ripple effect of that one bombshell decision?
Right. It has no legal effect other than in that one particular case, because these are individual criminal cases. You don't really do class actions in a criminal proceeding. So, as a practical matter, there weren't the DOJ stopped bringing 1326 cases before Judge Due, and didn't really bring them in her division of Nevada anymore. But the DOJ was still bringing them everywhere else. And the other thing I'll say is that, you know, as we were litigating this, there were some of the prosecutors, and in fact, it became the general position of the DOJ that race actually was not a motivator behind the original passage of the law. Um, that was pretty shocking to me, that you could look at all this evidence and say, no, we deny that there was any racial motivation initially behind this law whatsoever. So,
Is
I
that?
think,
Oh, go ahead. Sorry.
no, go ahead.
Well, I'm wondering because once the bomb goes off in Nevada, it really only applies to Nevada. But of course, every lawyer in other jurisdictions is going to try to use this argument in their cases. And so I'm just kind of wondering, to my knowledge, nobody else has been successful. So what are the legal justifications for courts? Well, by the way, I will go back to this fast track thing. It's
Mhm.
very hard to raise this issue in a run of the mill 13, 25, or 26 case. Why? Because of fast track. They give you a plea offer and they say, take it or leave it. And if you say, well, I'd like to litigate this issue about the racist origins of the statute, they put two middle fingers in the air and say, then you don't get a plea bargain. And then you have to spend months, if not longer, litigating these issues. And if you get convicted and you go to sentencing, your sentence is longer. So it's not often in a client's best interest to raise a perfectly legitimate legal issue, because it's just going to draw out their case, and keep them incarcerated longer than they might otherwise be.
Right.
So it's super difficult to make. Otherwise, we'd be making these in every single immigration case we ever had in every jurisdiction in the country, but that's not happening. But it is happening here, there, and smatterings, right?
Right.
But it's not succeeding. Do you know generally what the judges are hanging their hat on to say denied?
Well, most of the judges are saying, look, even assuming that there was racism in the 1920s, Congress reenacted the law in 1952 when it created the Immigration and Nationality Act of 1952. So we think that that was sort of a wipe the slate clean kind of situation. I think we have two responses to that. First of all, there was a lot of evidence independent of the 1920s that there was also racism in the passage of the immigration law in 1952. There was about 1,000-page report that I went through and looked at, and they talked at length about how, yeah, we're aware that there was this motivation in the 1920s to, keep people out because of their race. And well, we don't really have a problem with that. And then they also talked in this report about the necessity of keeping, the population white. There were a lot of people in Congress that, for instance, 2 months before this law was passed, they passed a law called the Wetback Bill. There, Congress was doing a lot of stuff around this time.
Yeah.
So I think the first
and it's the height of Jim Crow. It's before the Civil Rights Act in the 60s,
exactly.
Which means that racist legislation was still prolific. I mean, it was all around us everywhere.
Right.
So but no, this one particular statute is somehow we've wiped the slate clean. Okay, yeah, right. That makes a lot of sense. Right. That's what we call what is that? Intellectual dishonesty, I think, is what we're talking about here.
Pat Caron, who was a senator from Nevada, he was the chair of the House Immigration Committee, and he is on record as using the term wetback to refer to anyone from Mexico, whether they had legal status or not.
Wow.
So, yeah, there's a lot of independent evidence that there was racism going on during that time as well. But another basis that some of the judges have used to deny the motion is to say, well, we just think that it's been done a number of times, and every time that you have a reenactment or that you pass it again, that wipes the slate clean. And so because of that, we think that it's passed and, it was amended again in the 80s and the 90s, and you can't show racism every single time. The idea essentially being that we don't look to the original law or the original history. We look to whether it would be considered or could be passed right now.
So this is the one in Nevada is the only one that's has won so far, right?
Right.
Okay, and then that goes to the next process is an appeal. So the government appeals this, of course, because they don't like this ruling.
Right.
And that goes to the Ninth Circuit. When we're in the Ninth Circuit, Nevada's in the Ninth, Arizona's in the Ninth, California's in the Ninth. So that's interesting. So then you get to file the brief, the appeals court brief, right? And I do want to just go to that for 1 second, because as I mentioned before, Kara is a storyteller. And she's a playwright, and that permeates all of her legal advocacy, but it very clearly permeates her legal writing, because, we do this on several episodes where we kind of take sentencing memos and dissect. We did it on some of the high profile cases like Elizabeth Holmes, and, just to see like what is the level of advocacy storytelling in these pleadings, because some of these pleadings can be deadly dull and convoluted and confusing and boring and with no story at all. So I just want to read you the first sentence of this introduction in this in your brief, in your appellate brief, because I think it tells the whole story of how where your heart is. In 1929, Congress enacted the first law criminalizing illegal reentry into the United States. Every historian who has studied this law now agrees that Congress created it for one primary purpose: to keep the Mexican race out of the United States. I mean, you talk about opening hot, start with a bang, like, exactly, and it's a roadmap, so it hits you in the face, and it's clear, it's very clear, but it also says this is where we're going, so buckle up and come with me on this ride. I could go, every one of those paragraphs after that is just as good. I could go down the road, but I like to highlight examples of very powerful, good writing, and this is one of them.
Thank
nice
you.
work. Nice work. Yeah.
I got to say, I have not always been story-based, and it's strange because when I I did a lot of theater and playwriting and that sort of thing before I went to law school. And when I then went to law school, I was trying so hard to construct this artificial wall between my creative playwriting, storytelling side and my legal side, because we were all taught in law school, well, no, you have to sound like you're using big words, and otherwise you won't get respect and no one will listen to your argument. And I, of course, tried to do that for a number of years, like I think many of us did. And then it hit me, no, no, the stories are absolutely what get the
Hmm.
judges. They will never admit it, but it is
Yeah,
absolutely what
a
gets them.
1000%. And I say this all the time. We are really taught all wrong on so many levels, and we're taught to be automatons and not human beings. And
Right.
you're
But
absolutely right. Did you act in those plays too, or were you just the writer?
no,
Okay.
no. Um, but yeah, I even tried to figure out, how do I use storytelling in this challenge? When I was drafting the motion, for instance, there are those factors that show, okay, this is how we see if there's a discriminatory intent. And I knew that if I just did a legal argument and tried to say, okay, well, here's, why we meet these factors, blah, 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 the judges were not going to read it. And if we put the story separately, they were not going to read that. So what I did is that I put those factors in a chronology and then wove the story into them. In other words, I didn't really have a separate statement of the facts in the original motion. I just told the story by going through the factors. And it was my way of forcing the judges to read the story as part of the legal analysis. Because I think a lot of times, if we don't do that, judges say, oh, well, that's just so and so going off, and I don't need to read it. I can just go to the legal part of it. So I think it's really important to not try to treat those as separate things.
Love it. Love it. All right. So right now where we're at, that everything's pending, the cases before the Ninth Circuit, the oral arguments have happened. So what happens is you file the paper, the brief, that beautiful thing I just read you from, but then you go into court, and I know it was Professor Chemerinsky went to court in the Ninth Circuit to have what's called oral arguments, which is where they make their case before this panel of judges, and we're just waiting now to see what happens next, right? What do
Right.
you think? What do you think happens next?
We had oral argument in December. We are still waiting on a decision. We have oral arguments going up in a lot of other circuits. We have one in the Third Circuit in late May, the 2nd, the 7th, the 11th. That we're waiting on a decision in the 10th Circuit. It's just going up in all the circuits. And again, I'm not sure we're going to win. I think there are any number of ways that judges can figure out to deny that this history really controls. But again, I'm not sure it's the point. The point is that we need to be calling this out, and we need to be asking and making the point that this is not some sort of sterile law that exists in a vacuum. This was passed for a particular reason, and it's still being used for a particular reason. When during child separation, there were quotes from Stephen Miller, from Jeff Sessions, that specifically referenced the 1924 law, that specifically said, we need to think about going back to that. Trump gave a speech in Minnesota about talking about the racehorse theory and good genes.
Mm.
So, there have been, for instance, in an ICE detention center in Georgia, there were credible accusations of mass hysterectomies happening. So this is really
Yeah.
not a past is in the past thing. They're just echoes of those movements, those desires to intertwine race and immigration, that have kept coming back and coming back in various forms
Yeah.
up till today.
Even recently, the former guy's stump speech has talked about baby bonuses. And to me, that smacks of they're not gonna give, that that's clearly white. This whole thing is about white people needing to have more babies. Arguably, the anti-abortion stuff is the same thing. Replacement theory, which we hear about all the time now. I think people, the fucking Nazis marching in Charlottesville, screaming Jews will not replace us, but this I think we look at it, or maybe even I did, is this idea that they don't like it because it's taking their jobs or things like this, but it's really, to me, it's shades of the mongrelization thing that you bring up. It's not just replacing us at work, it's mixing the races and whatever, the polluting the genes and everything else. That's what replacement theory really is at its core. I never really thought about it until now, but that's definitely a part of it. And it's only getting worse today, which is even more mind-boggling, why these courts would then somehow be able to be like, that was in the past, there's no problem now. No, the problem is even worse now. So I have some more takeaways, but I want to make sure we've finished the story here in terms of procedurally, or what is there anything else we need to know about where this case is going, or what else?
I don't think so. I think we wanted to talk a little bit about how can you use this in a sentencing context?
Yes. So here's one of the takeaways that we already had. Good writing. We've had a few. But I did one podcast a few weeks ago, and it was volume 1, essentially, of what I call my Fearless Lawyering series. And I think this might qualify as volume 2, because this really is a takeaway that you have to be creative and bold and fearless as a lawyer. There are a lot of lawyers who would look at this and go, it's probably not going to win. It's probably going to irritate my judge. Like, I don't want to make those waves. I don't want to stick my neck out. And I say, no, be brave, especially in a helpless, hopeless situation like the assembly line justice that is our immigration system. And so you can't make these in all these fast track cases, but every now and again, the right one's going to come up where you can, and you should. So that's my first takeaway: be brave, be fearless. And then this idea of storytelling, like what you did is tell the origin story of this law, and we love our origin stories, right? And that to me is a thing. Like, okay, so then that's what got me thinking about the Major Crimes Act and the federal jurisdiction on the Indian reservations. Tell that origin story, and think about any case you've got. How often do you go right to the legislative history and the congressional record? I would never think to take a look at these statutes on any case, and you just never know what you're going to find until you dig. And origin stories matter. Why are we here? How did we get here? How do we get to this moment in time? And I think it's powerful storytelling here, just for if I'm a judge and I've sentenced 1,000 of these people, these human beings, and then you come to tell me, did you know that you're basically implementing a law that was unequivocally based on racism? And if I had a heart and I was a human being, I would say, holy shit, no, I didn't. And I'm really not pleased to be a part of that cog in the wheel. And so, brave lawyering is one thing, brave judging is a whole other thing. And Miranda Duke was clearly a brave judge, because a lot of judges, they're going to find a way out of this, because they don't want to be the one that rattles the ground beneath the feet of the federal courthouse. So let's talk about this, because even in a fast track case where the outcome is essentially preordained, like these pleas are very specific. There's not a lot of wiggle room you get to argue in a lot of these, where the judge would have a lot of discretion to give a significantly reduced sentence. But there is sometimes a little bit of wiggle room. But even if there's not any wiggle room, could you still make this argument, and why?
100%. So, in addition to giving a shout out to Lauren Gorman, who did the Nevada case and just an amazing job at it, I also want to give props to a couple other people who, even before we did this as a motion to dismiss, actually used it first as a sentencing memo. It was first done, to my knowledge, by Sarah Brin, who was in our office for a number of years and is now in the Seattle office, federal defender office. She took some of this history and first started weaving it into a sentencing memo. And then she shared it with Nora Hirozawa, who is also in our office, but is now in a New York federal defender office. And Nora actually was the first person, to my knowledge, to use it in our district. She used it in a case with a guy who had spent 19 of the last 20 years of his life in prison for 1326.
Mm.
And if you think that these are, there are many times offenses that people are getting, a couple months or a year or a couple of years, but there are cases where people can get 6, 7, 8, 9 years. And
Yep.
if you then, come back because all of your family's here and you don't know anyone in Mexico and you don't know how to make a life there, and you keep getting caught, you're going to end up like Nora's client who spent 19 of 20 years here. So Nora was getting ready to go into sentencing. She didn't know how to make an equities pitch really well because her client, hadn't been working, hadn't been able to sort of show a lot of the good traits that you can show when you've been out or spending time with family or that sort of thing. And so she didn't feel like she had a lot to work with. So she took Sarah Brin's sentencing memo and basically filed it and went in before the judge and argued this racist history and talked about how that needs to be considered under the 3553A factors, because you need to consider that these are offenses that are essentially trespassing. 99.9% of the time, it's someone who's either trying to reunite with family, flee persecution, or put themselves and their family members in a better economic position. So when you look at the nature, circumstances, all those factors, this is a law that became a crime and yet doesn't necessarily have a lot of the quote unquote dangerous aspects to it that many things that are criminalized do.
Yep.
So Nora went in and presented this and got a time served sentence for her client. So
Nice.
it is absolutely something that you can use in the sentencing context. Now, you need to obviously, as always, read your judge, know who you're going in front of. Some judges are not going to respond favorably. Nora happened to, know that the judge in that particular case would likely be open to hearing this, and she did it really well. So, you need to choose your time and place, but it's already paid dividends in that respect. And so, even if you don't feel like you have a case or you have a client or you have a judge that you necessarily can run the motion to dismiss in, I think you could always consider it for sentencing purposes.
Yeah. And I started out by saying, I call this studio 3553 because that is really the most important statute in the entire federal process, I think. And you mentioned, invoking the nature and circumstances of the offense, that this is essentially glorified trespassing. And I think there's another provision in 3553 that I think is worth bringing up, which is you have to weigh the need for the sentence, look at whether the sentence promotes respect for the law and equal protection, equal justice under the law is how we promote respect for our citizens. It's the cornerstone of our entire justice system, or at least it's supposed to be. And so the argument I would make is to say, when you perpetuate a racist statute, you are in effect promoting disrespect for the law.
Yeah.
And
I think
that's bad.
Another way to do that through another route is to talk about it in terms of Kimbrough. And we kind of all know these Kimbrough cases that allow federal judges the authority to disagree with the guidelines as a policy matter.
Mhm.
This really came up a lot in some of the crack cocaine disparities, where judges
Mhm.
could say, I don't want to impose a sentence in this guideline range because I think it's ridiculously out of whack with where it should be, and partially because of racial reasons. So there's no reason that a federal judge couldn't say, well, yes, your guidelines range for this 1326 is 60 to 70 months, but I disagree as a policy matter that that should be the guidelines range under Kimbrough. I am choosing to exercise my Kimbrough discretion to vary downwards on that basis, based on this racist history. There's absolutely nothing that would keep a judge from doing that.
Yeah, and this is maybe too far into the weeds in the plea process, but if you sign a fast track plea that says definitively you have to get this sentence, and
Mm-hmm.
a judge doesn't want to give you that sentence and wants to give you less or time served or whatever, the judge has the power to reject that plea agreement. Now, if he does, he has to give each side the opportunity to withdraw their plea. And if the government's really mad about it, they could just say, well, I'm not giving any plea and I'm going to trial. But that would be still, well, first of all, that would piss the judge off because they're going to trial in front of that judge.
Right.
And that's not going to go well. So I don't think a prosecutor would do that. But even then, why not plead straight up at that point? You don't need a plea agreement if you have the same charge that you're pleading to, because that judge is going to give you the right result. You don't need a plea. You don't need the government. You don't need any of it.
Exactly.
And I'm sure that's going to be a rare occasion, but we got to look for those openings. And I'll tell you what, just this, it may be a small thing, but even when you have no leeway and the outcome is predetermined and there's no way the judge is going to reject the plea and send your client on their way, it, I more often than not still make whatever argument I feel like is morally correct to make. I make it.
Mm-hmm.
And I'll tell you why. Because we are here to tell our clients stories. We are here to be their voice. And even when I've had, and I don't have to be too dramatic and make such a federal case out of it, but I will say what needs to be said. I'll speak my truth. And the reason is because that is the only gift that I can give to my client in that moment. Because in those cases, I often felt like a potted plant. Like I was just there to put the mark of, oh, he had counsel and all the I's were dotted and T's were crossed. So everything's legit, when we know in our bones there's nothing legit about it. And we're just being made to stand there and suck it up so they can keep the wheels of justice grinding forward. And so, and I can remember times, I don't even remember this one case what I was saying, but I spoke my truth and the judge said whatever and, sentence, and that was it. But I remember the client's reaction to me after. We get like 2 seconds at that podium before they got hauled off in chains. But he shook my hand and he had tears in his eyes and he said, thank you. And thanks for what? He got a shitty sentence. And he thanked me. And at that moment, I knew it was just important for that man to have a voice. And that's our
100%.
that's our job. And I think that goes back to fearless lawyering, because most of the time we're like, I don't think I should No, you stand up, you speak your truth. And I think if you do it enough and say it enough and it gets ingrained into the heart and soul of this process, then maybe change does happen.
100%. And I think, our clients may not know the law of Arlington Heights and they may not know the history of this law, but I guarantee that they feel it in their bones that this law is racist, because they are going in to a plea, a sentence, or whatever, an initial, and they're looking around and they're seeing that everyone charged under these laws has the same color skin as them, looks like them. And so it doesn't matter whether, a judge ultimately says, well, I think that the reenactment cured this or blah, blah, blah. If your client, for at least that one moment, feels my lawyer understands that this system is not fair, that it is stacked against me, and that it is frankly designed to target people who look like me. and never, ever underestimate the importance of letting our clients know that we see that, even if we can't always do anything about it.
Yeah, amen to that. And then the last thing is get creative with your language and do more storytelling. And I think about Henry Lee in the O.J. Simpson trial, and he had a great visual, just so sticky. It stuck with me. Well, we all know if it doesn't fit, you must have quit. But he said on the stand, if you are eating a bowl of spaghetti and you find a cockroach, you don't keep eating before you throw the whole bowl out. And I think about that in this case, Judge. We've got it right here in black and white, the racist origins. And how much more of this are you going to eat? This meat's been sitting out on the counter for 3 days straight. Do you still want to take a bite? You do want to be a part of this process? Anyway, I think we've made our point. We could keep going.
Can I add one more?
Yeah, please.
Takeaway?
Yeah.
Okay, so the last takeaway that I would say that has been really important to me, and I don't think I fully realized until I got into it, is how important it is to figure out creative ways to work with people outside the legal community. So we started working with these expert witnesses, these historians. And now we have this great coalition where, we talk to them, they come to our oral arguments, I do presentations for their classes. We have this wonderful kind of intersectionality between history and law and community organizing. And, there's a huge number of allies and advocates that have been supporting this argument and writing stories briefs and putting, doing symposiums online and making documentaries about this. And I think sometimes as lawyers, we can very easily just put our head down and think, okay, I just write my brief and then that's it. But we miss a huge opportunity to make a much more powerful presentation if we get creative about who our allies are and how we can bring them into our world and how they can bring us into theirs.
Absolutely. I love that. And that's an awesome place to stop. I'm going to put a bunch of links in the show notes if you go to setforsentencing.com to this episode, because we can link you to the audio from the oral arguments before the Ninth Circuit if you want to hear what the lawyers said in that case. And probably a couple other cool things. If you're wondering, if you're not a lawyer, because I know you're charged up to make all these arguments now if you're a lawyer, but if you're not a lawyer and you're wondering what you can do, maybe the first step is to go to the Florence Immigrant Refugee Rights Project, www.firrp.org, because they're a nonprofit and they help people in ways big and small every day, all day, and they could use a little bit of your money or maybe your volunteer time. So that would be my best advice if you're interested in helping out or learning some more. Kara Hartzler, thank you so much for spending this time with me on Set for Sentencing. I so appreciate it, and I so appreciate what you do, and I'm holding out hope for the ninth, for the big win in the ninth. And I'm sure that when this goes to the Supreme Court, everything's going to turn out just perfect.
How couldn't it?
How couldn't it?
Thank you so much for having me. This is really wonderful. And I am always happy to talk to people about this issue if people want to get in contact with me about it.
That's it for today. But before we go, I just wanted to take a moment and say thank you to you, the listener, for spending time with us today getting set for sentencing. Whether you're a lawyer, someone who could use the help, or maybe you're just a true crime buff who loves the inside scoop on how this whole thing works, I am so glad you're here, and I hope you keep listening. If you're interested in knowing more about what I do, mitigation videos, case consults, live teaching, on-demand educational content, books, articles, all of it, please visit www.dougpassonlaw.com. I'm Doug Passon. Until next time, hang in there. Wait a minute, that's a stupid way to sign off on a podcast about sentencing. Hang in there. What's the matter with you, man? I guess they call that gallows humor. Sorry. All right. Well, I will see you next time on Set for Sentencing. Bye-bye.